All right, Evan, you may be seated. Does the state waive the call, jury? Defense waive the call? Welcome back, everyone. It is now time for the presentation of the legal instructions. The instructions I'm going to give you on the law are contained in this booklet, which you will have with you during your deliberations. So don't feel like you have to memorize everything I'm getting ready to read to you. You will have this original copy, and if you need additional copies, we can provide you with additional copies as well. But I do want to direct your attention to the screen one last time, and we can turn the lights down, please. I sat in the back earlier and was able to see that. I know it's not too easy to see from the back row, but please follow along with me as I go through these instructions. The evidence and argument in this case have been completed, and I will now instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of others, but should consider each one in the light of and in harmony with the others. The indictment is the formal written accusation charging the defendant with a crime. It is not evidence against the defendant and does not create any inference of guilt. The defendant, Joel Michael Guy, is charged in indictment number 110145 with the offenses of first-degree premeditated murder, first-degree felony murder, and abuse of a corpse. To these offenses, he has entered pleas of not guilty. There are 7 counts in this indictment for you to consider. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. The elements of each offense the state is required to prove are as follows. I've placed counts 1 and 2 together because they charge the same offense with just different alleged victims. This is the offense of first-degree premeditated murder in counts 1 and 2. Any person who commits the offense of first-degree premeditated murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the victim. As to count 1, the alleged victim is Joel M. Guy Sr. As to the second count, the alleged victim is Lisa Guy. And 2, that the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of the alleged victim. And 3, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Third count, first-degree felony murder during first-degree premeditated murder. Any person who commits first-degree felony murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed Lisa Guy. And 2, that the killing was committed in the perpetration of first-degree premeditated murder of Joel M. Guy Sr. That is, that the killing was closely connected to the alleged first-degree premeditated murder of Joel M. Guy Sr. and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged first-degree premeditated murder of Joel M. Guy Sr. The elements necessary to constitute first-degree premeditated murder of Joel M. Guy Sr. have been defined for you above in count 1. You will refer to those elements here. The intent to commit the underlying first-degree premeditated murder of Joel M. Guy Sr. must exist prior to or concurrent with the commission of the act causing the death of Lisa Guy. Proof that such intent to commit the underlying first-degree premeditated murder of Joel M. Guy Sr. existed before or concurrent with the act of the killing of Lisa Guy is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether the killing of Lisa Guy was committed in the perpetration of the alleged first-degree premeditated murder of Joel M. Guy Sr. The killing of Lisa Guy may precede, coincide with, or follow the first-degree premeditated murder of Joel M. Guy Sr. and still be considered as occurring in the perpetration of the first-degree murder of Joel M. Guy Sr., so long as there is a connection in time, place, and continuity of action. Intended for this offense has been defined for you above under counts 1 and 2 in the definition of intentionally. I have placed counts 4 and 5 together, again, because they charge the same offense with two separate alleged victims. The 4th and 5th counts charge first-degree felony murder during theft. Any person who commits first-degree felony murder is guilty of a crime. For you to find the defendant guilty of this offense or offenses, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim. As to the 4th count, the alleged victim is Joel M. Guy Sr., as to the 5th count, the alleged victim is Lisa Guy. And 2, that the killing was committed in the perpetration of theft. That is, that the killing was closely connected to the alleged theft and was not a separate, distinct, and independent event. And 3, that the defendant intended to commit the alleged theft. The elements necessary to constitute theft are as follows. 1, that the defendant knowingly obtained or exercised control over property owned by Joel and or Lisa Guy. And 2, the defendant did not have the owner's effective consent. And 3, that the defendant intended to deprive the owner of the property. Again, the intent to commit the underlying theft must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying theft existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Again, considerations of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged theft. The killing may precede, coincide with, or follow the theft and still be considered as occurring in the perpetration of the theft, so long as there is a connection in time, place, and continuity of action. Intended or intentionally for this offense means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Now, there are some lesser included offenses that you may consider in the first 5 counts charging first-degree murder. And this first instruction tells you the order in which you're to consider the charged offense in relation to the lesser included offenses. In reaching your verdict, you shall first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count of the indictment. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense or unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count of the indictment, you shall return a verdict of not guilty and proceed to the other counts of the indictment. Here are the lesser included offenses, beginning with second-degree murder. If you have a reasonable doubt as the defendant's guilt of first-degree murder as charged in one or more of the first 5 counts in this indictment, then your verdict must be not guilty as of that count or counts, and then you shall proceed to determine his guilt or innocence of second-degree murder for that count or counts. Second-degree murder is a lesser included offense in each of the first 5 counts. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim. And in counts 1 and 4, the alleged victim is Joel M. Guy Sr. And counts 2, 3, and 5, the alleged victim is Lisa Guy. And 2, that the defendant acted knowingly. Knowingly for this offense means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown the defendant acted intentionally, and intentionally for this offense has been defined for you above under counts 1 and 2. The distinction between voluntary manslaughter, the next lesser included offense, and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. And the next is voluntary manslaughter. If you have a reasonable doubt as to the defendant's guilt of second-degree murder, a lesser included offense, then your verdict must be not guilty as to that offense or offenses, and then you shall proceed to determine his guilt or innocence of voluntary manslaughter, a lesser included offense. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant unlawfully killed the alleged victim. Again, counts 1 and 4, that would be Joel M. Guy Sr., and counts 2, 3, and 5 would be Lisa Guy. And 2, that the defendant acted intentionally or knowingly. And 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Knowingly and intentionally for this offense have been defined for you above. Reckless homicide. If you have a reasonable doubt as to the defendant's guilt of voluntary manslaughter, a lesser included offense, then your verdict must be not guilty as to that offense or offenses, and then you shall proceed to determine his guilt or innocence of reckless homicide, a lesser included offense. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, the defendant killed the alleged victim. Again, counts 1 and 4 would be Joel M. Guy Sr., counts 2, 3, and 5 would be Lisa Guy, and 2, that the defendant acted recklessly. Recklessly for this offense means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessly is also established if it is shown the defendant acted intentionally or knowingly. Intentionally and knowingly have been defined for you above. Lastly is criminally negligent homicide. If you have a reasonable doubt as to the defendant's guilt of reckless homicide, a lesser included offense, then your verdict must be not guilty as to that offense or offenses, and then you shall proceed to determine his guilt or innocence of criminally negligent homicide, a lesser included offense. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant's conduct resulted in the death of the alleged victim. Again, counts 1 and 4 would be Joel M. Guy Sr., 2, 3, and 5 would be Lisa Guy, and 2, that the defendant acted with criminal negligence. Criminal negligence means that a person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown the defendant acted intentionally, knowingly, or recklessly, and those terms have been defined for you above. All right, we will now turn to the last two counts, 6 and 7 counts charging abuse of a corpse. Any person who commits the offense of abusing a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant did physically mistreat a corpse in a manner offensive to the sensibilities of an ordinary person. As to the 6th count, the alleged corpse is that of Joel M. Guy Sr. As to the 7th count, the alleged corpse is that of Lisa Guy. And 2, that the defendant acted without legal privilege, and 3, that the defendant acted knowingly. In deciding whether the act was offensive to the sensibilities of an ordinary person, the jury must avoid subjective personal and private views and evaluate the sensibilities of a hypothetical average adult person, applying the collective view of the adult community as a whole. Ordinary persons means a person of ordinary care and diligence in relation to a particular thing. Knowingly for this offense has been defined for you below in the definition sections, which is next. There are no lesser included offenses for abuse of a corpse. So we will now look at the definitions. Unless a word is specifically defined elsewhere, folks, you're to look at this definition section. If there's a word that is not defined in these instructions, you're to use your everyday ordinary understanding of what that word should mean. Knowingly, unless otherwise defined for a specific charge, means that a person acts knowingly with respect to the conduct or the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause a result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally, and intentionally, unless otherwise defined for a specific charge, means that a person acts intentionally with respect to the nature of the conduct or to results of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause a result. Obtained means to bring about a transfer or purported transfer of property or of a legally recognized interest therein, whether to the defendant or another. Obtain includes, but is not limited to, the taking, carrying away, or the sale, conveyance, or transfer of title to, or interest in, or possession of property. Exercise control over property is defined as the right to direct how property, real or personal, shall be used or disposed. Generally, one must possess the right of possession in property in order to exercise control over it. Such possession may be actual or constructive, sole or joint. Also, one may have the right to control property without having a possessory interest. In such instances, if the defendant takes some action with the intent to deprive the owner of the property, and the defendant did so knowingly and without the owner's effective consent, the jury would be justified in returning a verdict of guilty. Anyone who is in a position to take some action that deprives the owner of property is in a position to exercise control. Property means anything of value, including but not limited to money, tangible or intangible personal property. Owner means a person other than the defendant, who has possession of or any interest other than a mortgage, deed of trust, or security interest in property, even though that possession or interest is unlawful and without whose consent the defendant has no authority to exert control over the property. Effective consent means assent in fact, whether express or apparent, including assent by one legally authorized to act for another. Deprive means to withhold property from the owner permanently or for such a period of time as to substantially diminish the value or enjoyment of the property to the owner. Expert witnesses. During the trial, you heard the expert testimony of Brad Park and Tom Finch, who were described to us as the experts in the field of latent print examinations, Kim Lowe, who was described to us as an expert in the field of serology and DNA analysis, Dr. Amy Halls, who was described to us as an expert in the field of forensic pathology, and Dr. Murray Marks, who was described to us as an expert in the field of forensic anthropology. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Flight. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt the defendant fled is a question for your determination. The law makes no precise distinction as the manner or method of flight. It may be open, or it may be a hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community, or a leaving the communities for parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight, if flight is so proven, together with all of the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by the facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Inference of destruction of evidence. Any attempt by a person to destroy evidence is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. While that inference is by no means strong enough of itself to warrant conviction, yet it may become one of a series of circumstances from which guilt may be logically inferred. Whether the evidence presented proves beyond a reasonable doubt the defendant so acted is a question for your determination. If this fact is proven, this fact alone does not allow you to find the defendant is guilty of the crime alleged. However, since an attempt by a defendant to destroy evidence may be caused by a consciousness of guilt, you may consider this fact, if it is so proven, together with all of the other evidence when you decide the guilt or innocence of the defendant. On the other hand, a person entirely innocent of a particular crime may attempt to destroy evidence, and this may be explained by proof offered or by the facts and circumstances of the case. Destruction of evidence of a crime is not proof of premeditation. Whether there was any attempt to destroy evidence by the defendant, the reasons for and the weight to be given to it are questions for you to determine. Identity. One of the issues in this case is the identification of the defendant as the person who committed the crimes. The state has a burden of proving identity beyond a reasonable doubt. Proof of identity may include identification testimony. Identification testimony is an expression of belief or impression by the witness, and its value may depend upon your consideration of several factors. Some of the factors which you may consider are the witness's capacity and opportunity to observe the offender. This includes, among other things, the length of time available for observation, the distance from which the witness observed, the lighting, and whether the person who committed the crime was a prior acquaintance of the witness. The degree of certainty expressed by the witness regarding the identification and the circumstances under which it was made, including whether it is the product of the witness's own recollection, the occasions, if any, on which the witness failed to make an identification of the defendant or made an identification that was inconsistent with the identification at trial, the occasions, if any, on which the witness made an identification that was consistent with the identification at trial, and the circumstances surrounding such identifications, and any other factors fairly raised by the evidence. Again, the state has a burden of proving every element of the crime charged, and this burden specifically includes the identity of the defendant as the person who committed the crimes for which he is on trial. If after considering all the proof in the case, including any identification testimony, you have a reasonable doubt the defendant is the person who committed the crimes, you must find the defendant not guilty. Prior statement of the defendant. The court instructs you that if there is evidence of an oral or written statement given by the defendant in this case, you may take it into consideration with all of the other facts and circumstances proven in the in the case. In considering the statement, it is for you, the jury, to say what weight you will give the statement. You may believe any part of the statement or disbelieve any part of it, and you may believe the whole statement or disbelieve it in its entirety. Fingerprint evidence. Fingerprint evidence has been presented in this case. You may consider this evidence in determining the defendant's identity as the person who committed this crime. Fingerprint evidence is circumstantial evidence. That is, it is proof of collateral facts and circumstances from which the existence of a primary fact may be deduced by you according to reason and common experience. There are no two sets of fingerprints exactly alike. For fingerprint evidence alone to sustain a conviction, you must find the defendant's fingerprints could only have been impressed at the crime scene during the commission of the crime. The weight to be accorded fingerprint evidence is a question for the jury to decide in light of all the surrounding facts and circumstances of the case. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by these rulings, the instructions, nor by any other remark do I mean to indicate any opinion as to the facts or as to what your verdict should be. The statements, arguments, and remarks of the attorneys are intended to help you in understanding and applying the law, but they are not evidence. You should disregard any statements made that you believe are not supported by the evidence. You are the exclusive judges of the facts in this case. Also, you are exclusive judges of the law under the direction of the court. In applying the law to the facts and deciding this case, you should consider all of the evidence in the light of your own observations and experience in life. The law presumes the defendant is innocent of the charge against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all the evidence in the case you are convinced beyond a reasonable doubt the defendant is guilty. The state has a burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. A reasonable doubt is a doubt based upon reason and common sense after careful and impartial consideration of all the evidence in this case. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. A reasonable doubt is just that, a doubt that is reasonable after an examination of all the facts of this case. If you find the state has not proven every element of the offense beyond a reasonable doubt, then you should find the defendant not guilty. The state must prove beyond a reasonable doubt all the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Knox County, Tennessee, and that it was committed before the finding and returning of the indictment in this case. Some of you have taken notes during the trial. Once you retire to the jury room, you may refer to your notes, but only to refresh your own memory of the witness's testimony. You are free to discuss the testimony of the witnesses with your fellow jurors, but each of you must rely upon your own individual memory as to what a witness did or did not say. You should not view your notes as authoritative records or consider them as a transcript of the testimony. Your notes should carry no more weight than the unrecorded recollection of another juror. We're almost done. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the questions? Has there been any evidence presented regarding the witness's intelligence, respectability, or reputation for truthfulness? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. A witness may be impeached by proving that he or she has made some material statements out of court which are at variance with his or her evidence on the witness stand. However, proof of such prior inconsistent statements may be considered by you only for the purpose of testing the witness's credibility, and not as substantive evidence of the truth of the matter asserted in such out-of-court statements. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has a right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved in the trial. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of the fact and issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact and issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one or say that one is any better evidence than the other. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. Thus, the important thing for you to keep in mind is whether a piece of evidence is convincing beyond a reasonable doubt and not whether it is direct or circumstantial. The verdict must represent the considered judgment of each juror, and each juror must agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to your own individual judgment. Each of you must decide the case for yourself, but do so only after impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury deliberation room. You may not use any electronic device or media, such as a telephone, cell phone, internet, or any social media site to conduct any research about this case until you have returned your verdict and the trial has concluded. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. You will be provided with forms for all possible verdicts in this case. The jury will complete the verdict forms, and your foreperson will sign the verdict forms. When you have reached a verdict, you will return to this courtroom, and your foreperson will deliver it to the court. So those instructions, at the end of the booklet, you will find a verdict form for each count. And we're going to look at those real quickly. This is, it says verdict form, first count, first degree premeditated murder. It says, we the jury find the defendant, Joel Michael Guy, and then you'll circle the appropriate letter. If you find the defendant guilty of first degree premeditated murder of Joel Guy Sr. as charged, you would circle the letter A. And then the foreperson would sign it and date it. Today is October 1st, 2020. If you unanimously find the defendant not guilty of first degree premeditated murder of Joel Guy Sr., you would then consider whether or not the state has proven him guilty beyond a reasonable doubt of second degree murder of Joel Guy Sr. If you find him unanimously guilty of that lesser included offense, you circle the letter B, again sign and date it. If you unanimously find him not guilty of that, you would then consider voluntary manslaughter and work your way down till you have a unanimous verdict. If you're unanimous that he's not guilty, you'd circle the letter F, not guilty, sign and date it. The second one looks just the same. It says, we the jury find the defendant Joel Michael Guy guilty of first degree premeditated murder of Lisa Guy. If that's your unanimous finding, you circle that A and sign and date it. If unanimous that he's not guilty of that, then you consider the lesser included in Lisa Guy in order from greatest to least. When you have unanimous verdict, you would circle that letter. If you unanimously find him not guilty, you'd circle F, sign and date it. Next, we have count 3, which is alleged to be the first degree felony murder of Lisa Guy during the perpetration of first degree premeditated murder of Joel M. Guy Sr. Again, circle your findings. Counts 4 and 5 look exactly the same, just different alleged victim. This is the first degree felony murder during the perpetration of theft. Count 4, it's Mr. Guy. Count 5, Miss Guy. And lastly, count 6 and 7 look exactly the same. This is the abuse of corpse. Count 6 is the corpse of Joel Guy Sr. Count 7 is Lisa Guy. If you find him guilty of that, you'd circle A. If he's not guilty of that, you'd circle B and sign and date it. And then count 7 looks just the same, except it's Lisa Guy. All right, we can have the lights back on. All right, folks, those are the legal instructions. As I said, I'm going to send this booklet back with you. You'll have it with you to refer to during your deliberations. I'm sending this one original copy back. If you want additional copies, let me know. We'll take the original back from you, make photocopies of that, and give you as many copies as you'd like. If each one of you wants to have one, we can accomplish that for you as well, too. Now, there's been a number of exhibits that have been introduced in this trial, and you will have those with you in the jury room. I want to point a couple things out. First, they're numbered. You may have seen that we had a little bit of confusion on some of the photographs. That probably has to do with my poor ability to add, but there is actually no exhibit 346 or 347. That's just, they were a group of photographs that I added wrong. So if you're looking for exhibit 346 or 347, it doesn't exist. We just had an extra number for that group of photographs. Also, have you noticed over the course of the week, the witnesses, when they would handle any exhibits, they would wear gloves? That's really for your protection. So we're going to have latex gloves. I don't think I have any latex-free ones. If you have latex allergies, maybe somebody else should handle the exhibits. You are free to examine these exhibits if you would like. Some of those have biohazard stickers on them. I would certainly caution you to be careful with these exhibits, but you're certainly welcome to look at them. Just wear gloves when you like to and be careful. One of the containers that is alleged to contain a caustic substance has been leaking. We left in that bag because it's been pretty well sealed, but we put an additional sort of a thicker Ziploc bag. It's there. You can look at it as well, too. I would just ask you not to open up any of those bags for everyone's protection. All right. And I think I have answered all the legal questions in my instructions, but invariably the jurors will think of something to ask me during the course of deliberations. If you need further direction on the law, the foreperson should write those questions out on a sheet of paper and sign it, give it to the court officer, they'll bring it to me. If I can provide you any further direction on the law, I will do that. As I said in the instructions, you are the exclusive judges of the facts, so that is up to the 12 of you to determine what the facts are. But if you're wrestling with the law, perhaps I can give you further direction on that. All right, so it is now time to begin deliberations, and we still have 3 additional jurors left over. And so I'm going to excuse the 3 of you. Once all the jurors leave, I'm going to have you remain in the back hall. I have a certificate of service to thank you for your service, and I'll give you some further discharge instructions, which are basically you're just discharged, and you can talk to anybody you want to at that point. The rest of you, what we're going to do is I'm going to have you go to where we're having deliberations. We found a large room in the building because you can't all fit in our conference or our jury room socially distanced. We do have a large room where you can spread out and maintain your distance. Nobody's going to be in there supervising you. I just ask you to be respectful for one another. All the recording equipment in there has been turned off. We've removed all the legal books, we think. There is no reason for you to go looking for any legal books or anything else. So you can keep your cell phones with you, but you can't use them in connection to this case. So don't communicate with anyone. Don't look up any definitions of words. Don't do anything with your phones. During breaks, you can use your phones to call your friends and loved ones. Once again, you are in charge of the breaks. Whenever you want to take a break, you can. We will have snacks for you as well, too, if you like those, and drinks. Just let us know. The court officers will be outside the door. If you have any questions or concerns, just let them know. So I want all of you, including our additional jurors, to take your notebooks with you now. The first 12 will go to the jury room, begin your deliberations. Once you have your foreperson, open the door, tell us who that is. We'll bring you in the exhibits. And you may now begin deliberations. Please go with the officers. If you just wait for me in the hall, I'll be with you in just a minute. Thank you. All right, everyone, you may be seated. All right, any issues from the state? Any issues from defense? All right, everyone, thank you so much for your efforts this week. It's a well-tried case. I know it's not easy under these circumstances. I think it was a fair trial. I really appreciate everybody's efforts. You conducted yourself very professionally, which is exactly what I expected, and was not disappointed. We have the best criminal defense bar in Knox County in the entire state, I can promise you that, and the best group of prosecutors that I've met. So thank you all so much for your hard work. I appreciate it. Court stands in recess till we have a verdict or a question.